सेक्शन 482, सेक्शन 482 हो गया। पावर टू पावर टू पावर टू रिक्वायर्ड अटेंडेंस ऑफ द विटनेस, पावर टू required attendance of witness. For effecting investigation, the police must be able to obtain information from person with the fact and circumstance relevant to the commission of the offense under the investigation. Under the investigation हो गया, under the investigation, under the investigation हो गया, under the investigation, under the investigation हो गया, under the investigation. Power to interrogate witness and to record their statement. Power to interrogate in order to facilitate the collection of the evidence. The investigating police officer has been given power to examine orally any person supposed to be acquitted within the fact and circumstance of the case. Except clause 1, such a person is required to be answer truly all questions related to the case, but case put him by such a officer, whoever is a case of the officer हो गया, case of the officer हो गया in decision of the Supreme Court in नादनी सेठपति वर्सी पी एल नांदनी हो गया, पी.एल. नांदनी। क्रिमिनल प्रोसीजर कोड 1973, क्रिमिनल प्रोसीजर कोड 1973 CRPC इज ए पार्लियामेंट्री नंदनी सातपति हो गया, नंदनी सातपति। बट इन recording of the statement, this investigating police officer may reduce into writing any statement made to him in the course of the examination of a person. Course of the examination of a person हो गया, course of the examination of a person हो गया, course of the examination of a person हो गया, course of the examination of a person, inventory value or statement made to the police. The statement made to the police are as three category. Statement which has been recorded as in FIR. Statement which has been recorded as in FIR. Statement recorded by the police in the course of the investigation. Statement recorded by the police but not falling under the 1 and 2 category mentioned above. Category mentioned above 157 former statement of the witness may be proved by the corroborate later testimony to the same fact. Testimony to the same fact. Inventory value of the FIR. Thought the FIR is not substantive evidence. It can be used to calibrate the informant under the Section 157 Evidence Act or to contradict him under Section 145 of that Act if the informant is called as a witness at the time of the trial. The FIR can have better collaborative value if it recorded before there is time and opportunity to embellish. Inventory value of the statement recorded by the police in the course of the investigation हो गया, Power of the judicial magistrate to record conscience and statement. Any conscience made to a police officer is totally inadmissible in evidence. As discussed earlier. Even the statement recorded by the police in the course of the investigation cannot be used for any purpose other than whose mentioned in the section 162 of the code. The reason for having such restrictive provision is obviously by and large the police is not has yet considered true true worth. Full stop. It is apparent that any power given to the police to record conscience or statement is misused more likely to misuse that or a police officer might in the apparent exercise of this okay. Therefore the code provided by section 164. Therefore, the code provided by the section 164 in a special procedure for the recording of the conscience and statement made during the course of the investigation by the competent judicial magistrate. Competent judicial magistrate full stop. The purpose of the special procedure is primarily to ensure that the conscience or statement are made voluntary and fairly and not under any pressure or influence full stop. A conscience record in according with the special procedure prescribed by the section 164 can be used in a substantive evidence. The record of such a conscience is admissible in evidence even thought the magistrate making the record is not called as a witness to formally prove it at the prove it prove at the trial of the accused person full stop because according to the section 80 evidence at the court is required to presume that the record is genius and that any statement has to the circumstance under which it was made a true and that such a conscience statement of the accused has been duly recorded full stop. A non-conscience statement recorded under section 164 is not substantive evidence, but if the maker of a such statement is called as a witness in the trial then this early statement can be used for a corroborating or contradicting this testimony in the court under the section 157 section 145 evidence act. Statement of the woman recorded under the section 164 clause 5a subclause a whoever can be used as an examination in chief as a specified in section 137 evidence act and can also cross examining the such statement हो गया. Any analysis of the section 164 bring out the following point okay. Consignation or statement can be recorded in the course of an investigation any at time afterward before the commencement of the inquiry of the trial. Exercised clause 1. Before recording a conscience, the magistrate is required to explain to the person making the conscience that he is not found bound to make such a conscience such be. If does not, it might be used as a evidence against the section 164 clause B. 164 clause 2. 164 clause 2 164 clause 2. 164 clause 2 164 maintenance and use of the case diary according to the section 162 clause 1. 172 clause. According to the section 172 clause 1, every investigating police officer is required to enter daily this proceeding in the investigation in a diary. Whose of such a diary shall set forth the time at which the information reached the investigating officer, the time at which he began and closed this investigation, the place or place visiting him, and a statement of the circumstance ascertained through this investigation. Section 172 clause 1. The diary is called the case diary or special diary. Special diary होगा special diary. Special diary होगा special diary. Procedure when investigation cannot be compelled within the 24 hours. Compelled within the 24 hours, a person arrested without a warrant cannot be detained by the police for more than 24 hours. If the police officer consider if necessary to the detain such a person for a long period for the purpose of the investigation. He can do so only after the obtaining a special order of a magistrate under the section 167 full stop. The scheme of the section is intended to protect the accused from an unscripted police officer. The object is to be see that person arrested by the police are brought before the magistrate within the least possible delay so that the magistrate could decide whether the person proceeding should further be kept in the police custody and also be allow him to make such representation as they may be wish to make they make to wish procedure to be followed on completion of investigation. Release of the accused when evidence as deficient if upon investigation it appear to the officer in charge of the police station that there is no sufficient evidence or reasonable ground of the suspension to justify the forwarding of the accused to be magistrate. Accused to be magistrate to a magistrate. Such officer shall, if such person in a custody, release him on this executing a bond with or without surety has a officer may direct to appear if when so required before a magistrate empowered to take cognizance of the offense on a police report and to try and accuse or commit him for trial. Section 169. Case to send the magistrate when evidence is sufficient. The following procedure is to be followed when accused is forward to the magistrate. If upon investigation there is a sufficient evidence or reasonable ground to justify the forwarding of the accused to the magistrate. The SHO shall forward the accused under the custody to a competent magistrate, or if the offense is bailable. And accused is able to give security, shall take security from him for this appearance before such a magistrate. Section 170 clause 1. In the situation mentioned in the A above, the SHO shall send to such magistrate any weapon or any article within any justice हो गया, some basic consideration यानी कि local jurisdiction of the court and the police. As seen early, every state is divided into suitable territorial unit for the purpose of the administration or criminal justice. Full stop. For these territorial unit, separate court have been established. For these territorial unit, separate court have been established. Full stop. Now, having regard to the size of the state, the distance of the court from the place of the crime, and difficulty of the transport in the interior, it would seem expedient and desirable that the inquiry or trial in respect of any offense should ordinarily take place in that court which is nearest to the place of the crime. If the trial is conducted in immediate vicinity of the crime, Victimity of the crime. Witness will be readably available and it could be consent of the both the prosecution